Boa tarde a todos. Good afternoon, everyone. Welcome to the table topic number 8. The table topic regarding anti-suit injunctions and standard essential patents. My name is João Cunha, and I'm a partner of Guzmão e Labruni, Advogados. And I'm extremely glad to moderate this panel, which will provide the audience with relevant updates regarding anti-suit injunctions on standard essential patents. This topic, it's been quite important in patent litigation, particularly in the enforcement of standard essential patents and friend negotiations. It will be a very interesting topic, and I hope you like it. We selected two external foreign experts on the topic, one with a civil law background and another one with the common law background. And also my partner, Marcos Blasi, will join this panel as a speaker, providing the Brazilian scenario on the topic. So on behalf of ABPI, I would like to welcome our speakers and thank you so much for being here in the summer of Europe. So in the middle of your holidays, to be here for us, it's a great honor. As I mentioned, Haris and Ari are well-known experts on the topic. So the first one to speak will be Haris Tsilikas. Haris Tsilikas, it's an IP and antitrust consultant and has been advising clients on IP and competition law issues in standardization for over 11 years. As both a doctoral researcher with Max Planck Institute for Innovation and Competition and an independent lawyer and consultant, he has developed extensive experience regarding standards development organizations, SDOs, and competition law, particularly governance aspects. Haris has received a number of awards in the field of competition law and IP, both in Germany and in the United States. And Haris just published a very recent article exactly regarding this topic. Haris is going to provide a broad update, not only in the continental Europe, but also in the US and a bit of China. So it will be a very interesting update in many jurisdictions. And then the second one to speak is Mr. Ari Lakonen. Ari is a partner of Powell Gilbert, a London-based specialist intellectual property law firm. Ari has a computer science degree and PhD from King's College, and he has a huge breadth of experience in the electronics, IT, and telecom sectors derived from his in-depth technical knowledge from experience both in-house and external legal counsel. Ari is the first Deputy Reporter General of AIPPI and has published widely on all aspects of IP law. And finally, Marcos Blasi, my partner in the firm, and also is going to provide an update on the Brazilian aspects of this topic. And Marcos is one of the partners in charge of Guzmão e Labruni's litigation practice. Marco has more than 18 years experience as both outside and in-house counsel on innovation and IP litigation, consultancy and contracts, having formerly headed the IP, contracts and innovation legal department of a publicly traded and globally inserted Brazilian company. He holds a PhD in business law by University of São Paulo, an MBA in innovation management by FIA, and an LLM intellectual property by WIPO and University of Turin. And Marcos is also a member of the board of counsel of the ABPI and co-reporter of the national group of ABPI. So I would like to welcome our speakers and so give the word for Haris for the first presentation. So thank you very much, Haris, for accepting the invitation on behalf of ABPI.
Thank you very much. It's a great privilege to be among you for the Congress. I hope we have a nice panel today on a topic that is very exciting. It touches upon issues of patent law, antitrust, contract law, and as we will see also, international trade law. Let me share my screen, my slides. I hope you can see them. Let me start with a brief introduction on the topic, and by discussing a bit about the broader picture, the international system of standards development and licensing of patents on FRAND terms. To begin with, standard essential patents are patents that are technically essential to implement a standard, such as 4G, 5G, Wi-Fi, AAC, Bluetooth, standards that are familiar to all of us in our everyday lives in the equipment that we use. Standards are developed by organizations called SDOs, Standards Development Organizations, which have various rules and policies, including policies on licensing of essential IPR. An example of a very famous SDO is ETSI, the European Telecommunication Standards Institute. ETSI, in its own IPR policy, provides under Section 6 that patent owners are to submit a voluntary FRAND undertaking, which means that licenses for essential patents would be available on fair, reasonable, and non-discriminatory terms. And now to move a bit closer to our topic, one source of complexity is that patents are national property rights. They are territorial in scope, yet many stakeholders have portfolios of multiple SEPs, which are protected in many jurisdictions. Standard essential patents are licensed in FRAND negotiations, which are expected to take place in good faith, having a balance of rights and obligations for both licensor and licensee. According to the case law of European courts, FRAND is not only the royalty rate. The rate is only one of the terms of the license, but it also relates to how the parties behave during the negotiation. So FRAND is also a conduct, a manner of behavior. In the EU, the framework is set by the Court of Justice of the EU in its 2015 Huawei versus ZTE case, where the court developed a very detailed framework on how parties are to conduct themselves in licensing negotiations. And this framework has been further elaborated by national courts in Europe, in Sisvel versus Haier by the German Federal Court of Justice, and in Unwire Planet versus Huawei, a decision of the UK Supreme Court. Of course, it is sometimes the case that parties do not agree on what terms are in fact FRAND. So negotiations may break down. Parties might choose to arbitrate or to go to mediation, but also it is often the case that we have litigation of patent, contract, and antitrust claims. For instance, we have claims for patent infringement, claims that antitrust laws have been breached, and then courts in several jurisdictions might be called upon to adjudicate the same dispute. So this is how we have a situation of overlapping jurisdictions. And one way some courts have chosen to handle this situation of overlapping jurisdictions is to issue unlisted injunctions, which are effectively court orders barring a party to the proceedings from initiating proceedings or continuing proceedings in another foreign jurisdiction. For most European courts, the main factors that weigh in their assessment of whether to grant this remedy is first and foremost the rule of law and the protection of fundamental rights. IP is a property right that is protected in the EU under Article 17 of the Charter of Fundamental Rights. And we also have the right of effective judicial protection, access to justice, fair trial, fair hearing. For instance, in Europe, this is enshrined in Article 6 of the European Convention on Human Rights. A further priority for courts would be to safeguard national sovereignty, to limit interference with the lawful assertion of jurisdiction, and preserve their autonomy vis-a-vis a foreign court. Furthermore, courts might also consider the impact of an undisputed injunction on so-called international committee, which is something a concept relating to the respect courts have for the decision of another sovereign court in another sovereign jurisdiction. And we have here a very early definition by the US Supreme Court in Hilton versus Guyot. And finally, another concern that courts may take into account is the effect of the undisputed injunction on the broader standards development ecosystem. How will the undisputed injunction impact upon the patent holders' rights, including the right to injunctive relief, and what would this impact in turn imply for innovators' incentives to contribute technologies to standards? Let me go briefly through the US approach, also probably should say approaches to the issue of undisputed injunctions. Undisputed injunctions is a topic that has never been adjudicated before the US Supreme Court, so we do not have a comprehensive approach when it comes to the US on undisputed injunctions. We can divide the approach of the US courts in two. One, let's call it conservative approach, which is more hesitant to issue an undisputed injunction, and a more liberal, let's say, approach. The conservative approach is followed, I would say importantly, by the DC Circuit. It involves a two-step test. One, whether the threshold requirements are satisfied, and these are that the parties in both the US proceeding and the foreign proceeding must be the same, and the outcome of the US case must be dispositive of the foreign case. And the second step, these circuits will assess whether the foreign litigation presents a threat to a vital US interest, and whether this interest outweighs concerns over international committee. And this is a very high bar, and undisputed injunctions are rarely issued by these circuits. On the other hand, the liberal approach, which has also been followed by the Federal Circuit in one occasion, is more permissive. It emphasizes more concerns over judicial efficiency and avoidance of conflicting rulings in international litigation. Again, the first step is the same, the threshold factor, same parties dispositive of foreign litigation, but there is a big difference in the second step, where the liberal approach applies the so-called Unterweser factors, which are namely that the foreign litigation frustrates the policy of the forum of the US, and that it is vexatious or oppressive, that it threatens the courts in rem or quasi-in rem jurisdictions, and it otherwise prejudices equitable consideration, as the courts say. In the SEP context, we have so far 4 cases involving a claim to an undisputed injunction. And in one of these 4 cases, an undisputed injunctive order was actually issued by the Ninth Circuit of the Court of Appeal in Microsoft versus Motorola. In this case, which involved litigation between the two companies in multiple jurisdictions, but the specific request by Microsoft was with regard to proceedings in Germany that resulted in an injunctive order being issued, if I'm not mistaken, in Düsseldorf. The court found that the parties were the same in both cases, and the outcome of the US case, which was to determine a front rate for Motorola standard essential patents, was dispositive of German proceedings, which were patent infringement proceedings regarding the same patents. Moreover, the court found that the foreign litigation was vexatious, And it also aimed at interfering with the ability of the US court to set front terms in this dispute. In another instance, in IBCOM versus Lenovo, Lenovo requested an anti-suit injunction, but as we will see below, this prompted a very swift response by courts in the UK and France, and the case is still pending. And finally, we had 2 cases where US courts denied the request for an anti-suit injunction in ZTE versus Vrinko by the Southern District of New York, and in Apple versus Qualcomm in California. In both of these cases, the claimants failed to establish the threshold requirements, especially that the US litigation was dispositive of the foreign litigation. And now to the main part of my presentation, which is the approach of anti-suit injunctions in Europe. We have to distinguish between 2 scenarios. One where a court in an EU member state is called upon to give an anti-suit injunction which is addressed at proceedings in another EU member states. And the second scenario might be where the foreign proceedings are in a non-EU member states. When it comes to concurrent proceedings within the EU, regulation Brussels 1 applies, and under this regulation, the court that has first seized of a dispute has an established jurisdiction over the case. Therefore, anti-suit injunctions are in principle not available when they are directed at proceedings in another EU member states. This has a complication, which Ari will discuss in more detail in his own presentation, because UK was part of this system, but now it is not. So we have a change of how litigation will work within Europe over the next years. The Court of Justice has also taken a very critical view of the anti-suit injunction remedy by saying in 2 cases, in Allianz versus West Tankers and in Turner versus Grovit, that anti-suit injunctions directed at proceedings before another court in another EU member state may strip of this court of its lawful powers and jurisdiction under EU law, and run counter to the relations of mutual trust that courts and jurisdictions are expected to enjoy within the EU. Within the SEP context, we have had anti-suit injunctions I would say anti-suit injunctions, which are orders barring the defendant from claiming an anti-suit injunction in another foreign jurisdiction. In the case of IBCOM versus Lenovo, the Paris Court of Appeal decided that if the US court, in this case in California, were to issue an anti-suit injunction, this would inflict upon the patent owner manifestly illicit harm, because they would deprive them of their rights under French patent law. This would constitute, according to the court, an infringement of the patent owner's fundamental rights to property and effective judicial protection. Similar conclusions were reached by the English court in the same case. In Germany, which is the jurisdiction that has the highest number of cases involving standard essential patents in Europe, because it is the largest market and it has a very efficient judicial system, we have had the last years an increasing number of anti-suit injunction cases regarding standard essential patents. Mainly, the context here is the licensing disputes we have been observing between essential patent owners and companies that are active in the automotive space, as we will see below. We had a series of cases, mainly from the Munich courts, involving Nokia and implementers belonging in the automotive industry, and namely Daimler and Continental. In these cases, the Munich courts, both the district court and the Court of Appeal of Munich, issued an anti-suit injunction, AASI, because in the view of the courts, an anti-suit injunction interferes with Nokia's property rights, or as the court said, quasi-property patent right under the German civil code. And if these were to be accepted, it would constitute the patent right without much practical value, since the right to exclude would be deprived. Moreover, the High Regional Court of Munich pointed out that under EU case law, and specifically under the case Huawei versus ZTE of the Court of Justice, the patent user can always raise a front defense in case there is an unreasonable exercise of patent rights on the part of the patent owner. In the latest development in the anti-suit injunction sphere, and we had again the Munich court last month issuing another anti-suit injunction in IP breach versus Huawei. What is peculiar in this case is that there was no issued anti-suit injunction by the Chinese court, but there were threats by Huawei in this case that such proceedings were to be initiated. And based on that, the Munich court granted the anti-suit injunction as a precautionary measure. This is actually a case confirming a preliminary injunctive order. So this shows that German courts are even willing to issue preliminary injunctions preventing a party to seek an anti-suit injunction. Moreover, a further concern expressed by the court in this case was that a defendant, a patent user that files for an anti-suit injunction in a foreign jurisdiction while litigation is pending before a German court might not satisfy the requirements to be a willing licensee under the Huawei versus ZTE framework. So to offer some tentative conclusions on the European litigation, mainly German litigation on anti-suit injunctions and anti-suit injunctions, we observe that the mood among German judges has shifted quite drastically over the past 10 years. For instance, in the case of Motorola versus Microsoft, we saw no reaction by the Düsseldorf court to the anti-suit injunction issued by the US court in this case. But now we see that German courts are able to issue swiftly anti-suit injunctions, even in the context of interim measures. Finally, another important contribution by German courts is that a request for an anti-suit injunction might indicate unwillingness on the part of the defendant to execute a front license. Beyond the litigation space, we have seen an impact of the anti-suit injunction debate also at the policy level. In particular, the EU has initiated an action before the WTO under Article 63, paragraph 3 of TRIPS. This is an information request to China and relates to 4 SEP cases, the 3 of which are anti-suit injunctions issued by Chinese courts, the courts in Shenzhen and in Wuhan. And mainly the EU is trying to establish exactly what is the legal basis for Chinese courts to issue these orders that limit the exercise of European patent rights by European courts. So thank you very much. You may find more on my paper, which was published, fortunately, last month. And thank you very much for your attention.
Thank you very much, Haris, for this comprehensive presentation. Very interesting to see this landscape in different jurisdictions, especially in Germany. And as we're going to see, I think the UK has a slightly different approach. And so I'm very happy to transfer to Ari to provide the UK perspective on this topic. So thank you again, Hari, for accepting the invitation. It's a great pleasure to have you here, and also Haris. So Hari, the stage is yours. Thank you.
Thank you very much. I'm just going to try and now share my slides. I hope everyone can see that.
Yes, it's perfect. It's perfect, Ari. Thank you.
Thank you. Okay. First, I'd like to start with a little bit of terminology, because one practical reason for this is that if you write out anti-suit injunction and anti-anti-suit injunction too many times in your slides, you use up a lot of words. And it's much simpler just to have those abbreviations in there. So that's not actually a legal abbreviation. That's just for my convenience. But I would like to sort of clear up some or really set the stage for everyone being on the same page on what is an anti-suit injunction. And I'm afraid I've taken the liberty of assuming that the UK definition of an anti-suit injunction is the correct one, and I'll come later on to my reason for doing that, because this isn't a random decision. There is actually a justification for it. But in the UK, an anti-suit injunction is really a case management power that the court can sometimes exercise if it has very good grounds for doing so. And this is a power for preventing a party in another proceeding. So if you've got the same party who is a party both in a UK case and in a foreign non-UK case, to restrain that party from taking some action in the foreign case, for example, for injuncting them to withdraw an infringement complaint and forcing them and mandating them to do that, or even injuncting them so that they cannot file suit in a foreign court. And that's why it's called an in personam power, because it binds the party. That's common in both of the proceedings. It doesn't bind the foreign court, because the UK perspective on this is that the UK court doesn't have the power to order a foreign court to do something, and it never would. For a number of different reasons, most of which are connected with policy. But an anti-suit injunction only binds a party to the litigation. And this is really the justification, partly why it may be okay to give anti-suit injunctions in certain circumstances. And the purpose of it is that is to prevent a situation from arising where a foreign action, a foreign proceeding, would somehow interfere with the UK proceeding. And it may be because it's vexatious, it frustrates the purpose of the UK proceeding, or it even is oppressive in terms of making it practically impossible for the parties to resolve the dispute that they have in the UK. This is a general power. It's not limited to FRAND type situations, nor is it limited to SEP type situations. It does require the judge to be satisfied that he's complied with the comity requirements. What this means is that the judge has to look at and respect, as Haris was saying a moment ago, has to respect the independence of the foreign tribunal and has to make sure that he's not stepping on the toes of the foreign judge or the foreign tribunal, and is preserving the independence of the foreign tribunal and is impinging on that as little as possible. This is I think in the expectation that the foreign tribunal would then do the same in exchange. But this is the comity is meant to be the mutual respect of foreign courts that they accord each other. And so the comity requirement is actually a serious requirement when it comes to anti-suit injunctions. This is a real requirement that you have to satisfy if you want an anti-suit injunction from the English court. Because the judge is going to start from the thinking that the foreign court is perfectly capable of regulating itself. Why should the UK court step in to regulate proceedings in a different court? And the judge is going to need to be convinced that if they take the step, the extraordinary step of regulating proceedings in a foreign court, then there's good grounds for it, and it won't upset or otherwise sort of cause a diplomatic incident with the foreign country in question. The most common situation, pre-IP cases where anti-suit injunctions were obtained was actually to protect arbitration. And the reasoning was that where the parties had concluded an arbitration agreement, and they had agreed between themselves that if they have a dispute, they're going to arbitrate it, say in London. Then, if one of the parties goes off and starts a court action, say in France or Germany or somewhere else, then it breaches the arbitration agreement. And the purpose of an anti-suit injunction in that situation is to prevent a breach of the arbitration agreement by allowing that party to continue to litigate in some foreign court. And that's really the genesis of this particular remedy for the parties. The other thing I should say is that we're talking here about an injunction. Under English law, an injunction is an equitable remedy. And so therefore, the normal requirements for an injunction have to be satisfied. That means, in particular, the balance of convenience has to be satisfied. What that in practice boils down to is that you measure two harms. You look at the harm that would be caused to the applicant if he does not get the anti-suit injunction, and you compare it against the harm that the other party would suffer if he is injuncted. And then you see who suffers the most harm. Should I or should I not grant the injunction, depending on the balance of convenience between these two different harms? And that's an integral part of the analysis. I think that played a part in the Lenovo case that was mentioned a moment ago. The reason I said that I rely on the UK definition of an anti-suit injunction is because it has been part of English law since probably about the 16th century. I say English law because Scotland and England didn't join into the UK until about 1707. So until that point in time, it was actually only part of English law. And it's that English law that survives nowadays, which still forms the core basis for this kind of relief. Anti-suit injunctions are dealt with on the same basis. So the idea is with a normal anti-suit injunction that you look at whether the foreign proceeding is interfering with the UK proceeding. With an anti-suit injunction, you look at whether the foreign anti-suit injunction is interfering with the UK proceeding. And if so, it may be appropriate to grant an anti-suit in order to restrain it. The most common use of anti-suits in English cases until about the mid-90s was nothing to do with SEPs in the first place. It was to do with regulating the jurisdiction of the courts. This was where, particularly in the mid-90s, it was a fashionable thing to do in the world of IP, to go for spider in the web type relief in Holland and other forms of pan-European patent enforcement actions, which did involve litigating a number of sort of IP rights that were national rights, as has been pointed out, but in one jurisdiction. And there, the kind of interference that could be had was that you could short circuit or circumvent an English litigation if you went to a different court and litigated the same IP right in a different European court. The Boston Scientific case is an example of that kind of case, where one of the parties was upset about an attempt by the other to circumvent the UK proceedings by litigating, in this case, in Holland, in a related litigation. And as Harris explained, in the West Tanker case, the ECJ, CJEU, then later on came to the conclusion that it's really the Brussels regulation within the EU that governs the allocation of jurisdiction within the EU, and courts shouldn't interfere with that and grant anti-suit relief, but courts themselves should decide when they've got jurisdiction, and if they have it, then they should keep it. And that should be the regime that applies going forwards, which then meant that anti-suit injunctions in the UK, in the context of IP cases, and also in the forms of other sorts of cases as well, went into a kind of winter hibernation after West Tanker. And that sort of explosion of relief that we'd seen before was curtailed. I'll come on to later on why that has changed. But and in particular its implications. But the reason is that of course during the last 40 years or so, when the UK has been part of the EU, the jurisdictional arrangements within the EU have been developed, and it started out with the Brussels Convention that turned into the Brussels Regulation, which regulated the jurisdiction of the courts and was the foundation for the West Tanker case. After the UK came out of the EU, there were attempts by the UK government that are still going on to sign the UK up to the Lugano Convention, which would provide a similar sort of jurisdictional framework. Those attempts to join by the UK to join the Lugano Convention have not been successful. So at the moment, the UK is in a free-floating situation and not bound by international conventions that regulate jurisdiction. This means that anti-suit injunctions are potentially back on the table. And also the decisions of the CJEU that related to this, for example, the Gatton Luck decision and other significant decisions, the Solvay and Honeywell decision, for example, are no longer directly applicable. There's no principle of law that comes out of those cases that applies to the UK's current situation. So the whole, not only is it anti-suit injunctions, which are open in an open field at the moment in the UK and unregulated, but it's also the conduct of pan-European litigation, which involves a UK element that is suddenly thrown into new doubt, and there is now uncertainty as to how those cases could be regulated and would be. Anti-suit injunctions are one of the mechanisms that the court has to impose some order on that, and so it's probably going to serve a useful purpose for that reason. Of course, one hopes that going forward, some sort of jurisdictional framework can be put into place, because that would simplify the situation a little bit. I should have said, if anyone has any questions, please do feel free to interrupt, and I'll do my best to notice your interruption and to respond to your question. The cases that I think are interesting to look at from a UK perspective are listed on my slide here. As Harris was saying, the initial anti-suit relief that we saw some years ago in the Microsoft and Motorola case didn't touch on the UK, but it was directed at Germany, and there the German courts took a passive role, and the German proceedings were stopped as a result. we saw an expansion of that in the Ericsson and TCL case. There was an anti-suit injunction by agreement. I think the by agreement part is quite important because their willingness of the US court to now grant anti-suit relief seems to be more limited. And and I wouldn't want you to go away with that with the picture in your mind that in Ericsson and TCL the judge was bending over backwards in order to grant anti-suit relief. That was not the case. Our firm actually represented one of the parties in this case, which is why I'm speaking at some length about it. But in this particular case, the Ericsson and TCL case, the corresponding UK proceeding was also anti-suited, and so that was stayed for a period of time. There were proceedings elsewhere too. So it had this was a case where the US grabbed the jurisdiction, carried out the FRAND determination, and the litigation elsewhere, I think, at least in the UK, came to a halt. The IPCOM and Lenovo case is another interesting one. Here I should say that our firm represented again one of the parties to this case, and so I'll tell you what I can tell you about it, and I won't what I can't. But it is an interesting fact pattern. Here in the US case, which was started by Lenovo, IPCOM's position was that the US court did not have jurisdiction in the first place. Lenovo's desired remedy in the US case was a FRAND determination. So IPCOM's position was the following. They were saying at the same time that the US court should not determine FRAND. But they also said that their patents are encumbered by FRAND limitations, and they acknowledged that they would grant a license on FRAND terms to their patents. They just didn't want the US court to determine what that should be. That's why they opposed an anti-suit injunction by the US court, because they said that there was no reason for the US court to grant an anti-suit injunction to protect the US FRAND determination, because they didn't agree that there should be one. And subsequently, that's why they also argued successfully in the case of France that the French courts should grant an anti-suit injunction so as to prevent a US anti-suit injunction to allow the French infringement proceedings to go ahead. So they were saying that they want their relief in terms of damages and injunctions, but they didn't want their relief when it came to FRAND. That case also illustrates an interesting aspect of practice in this area, which is that this kind of relief can actually be obtained really quickly. In the case of the UK anti-suit action that IPCOM filed, I remember coming into the office on, I think it was one rainy Tuesday morning at about 9 a.m. By 9:30, we'd been served the papers. By 10 o'clock, we were in court. And so that's roughly the sort of timeline you have to react to in some of these cases. There isn't often a huge amount of time, and the decisions that the judges therefore make are based on very little material sometimes. With the benefit of hindsight, of course, you could say that the court should have done this or should have done that. But it's a data point when looking at some of these decisions that they were not granted with months and months of argument prior to a decision by the court. Often it was just weeks. There have been a number of other decisions as well. Harris has already mentioned the German cases, where I think the principle on which an anti-suit injunction is granted is slightly different compared to the UK case. There's echoes of it, but it is a different basis. The Unwired Planet and Huawei case in the UK is an interesting example. That was, as I'm sure everyone here knows, that was the famous decision in which Colin Burst decided that he would determine FRAND, probably the first real FRAND determination in a UK court. There our firm acted for Huawei against Unwired Planet. And there was also an anti-suit injunction that was considered in that particular case relating to a SEP FRAND determination in China. And I think this was really the start of a number of other situations where, if I can turn to my next slide for a moment, where parties started to seriously consider FRAND determinations in China as being the solution to their problems. It's interesting, of course, to think, why should a country, country A's FRAND determination be a lot better than country B's? But parties will have views on that point. And a number of Chinese or China-based manufacturing companies did start then actively seeking FRAND determinations in China as being, in their view, the fairer way to assess FRAND. It's not mentioned on the slides, but an interesting example is the Philips and Xiaomi case. That was a case in which Philips served Xiaomi in the UK, and as part of the service process, they asked for an anti-suit injunction on an ex parte application at the time they were serving the papers on Xiaomi, and that was based on Xiaomi's past conduct in seeking anti-suit relief in China. So what that really, I guess the moral of the story on that in that case is that if one happens to be a Chinese company, then actively seeking a FRAND determination and having an active policy of seeking anti-suit relief in China can sometimes not be the most optimal way forward if courts elsewhere take that into account and protect themselves from that kind of situation. Here, the UK court did it. They gave an anti-suit injunction, expecting that Xiaomi is going to seek an anti-suit injunction in China. And I think from Harris, your cases, it sounds like Germany's done the same sort of thing as well. Different reasons, but same result. But that's really a special situation, because if you only have parallel FRAND proceedings in different countries, what's wrong with that? I think would be my question. There's nothing in principle unusual about having parallel FRAND proceedings. Maybe you'll have res judicata from one of those results that bites on the parties. But so what? Res judicata is relatively, it's a normal judicial mechanism, and if it happens, it does. Really, what the UK court's looking for when it's anti-suiting a parallel FRAND proceeding is whether there's additional factors that go with it. For example, a Chinese court or some other court, it's not particularly anti-Chinese, but it's really just some other court deciding for itself that it is going to have a monopoly on determining FRAND. Once a court somewhere else decides that that's the only court which is allowed to determine a particular issue, then I think the UK court gets interested and says, no, if this is properly before us, then we'll decide for ourselves what we can hear. And at that stage, they may decide that an anti-suit injunction would be justified. What it really boils down to is that there's, as I say on this slide, there's two ways or two key methods that the UK court uses to regulate its own proceedings. Bearing in mind that we've had parallel proceedings for decades now. For example, it's possible to have an invalidity case in the UK court and an infringement case at the same time, of course, because it's not bifurcated. And at the same time, you would have an EPO opposition. And in that situation, where you have a parallel EPO opposition, the approach of the UK court is to grant a stay sometimes of the UK case. Maybe it thinks that it's more efficient to resolve it first in the EPO. It'll stay its own proceedings and allow the EPO to go ahead and come to a conclusion, and then the UK case restarts. The other way it has to regulate proceedings is to grant an anti-suit injunction, which is a stay of the foreign case. And that's really, I think, sort of the fundamental basis of the thinking, except that the UK court does not really view itself as being the regulator of foreign cases. And so that is why the relief is granted so infrequently. It's very rare, actually. I think it's more rare than it would be in Germany by looking at your statistics, Harris. It's just a few cases, despite the remedy having been there for the last 500 years. But it's because the judges are very hesitant to grant it. I can see that it would serve a useful purpose elsewhere. I don't want to touch on the topics for Brazil, but speaking, just as an outside observer, I can see the logic in it, because why shouldn't the Brazilian court form its own view as to whether it should proceed in a particular case or not? And so I can see some logic there for a Brazilian court also granting an anti-suit injunction. But if I could give a few situations where the UK court would actively intervene, it's where it's the conduct that it's injuncting is particularly serious. For example, relitigating an issue is a clear attempt to get a better answer second time round, and that's a situation that the court has cured with an anti-suit injunction. That second bullet point there in the examples about granting an immediate anti-suit injunction is actually a reference to the Philips and Xiaomi situation. And that's something that the court has shown itself willing to do if the circumstances are right. And then, of course, there's the classic power with regard to regulating jurisdiction overall. So if we have a look at that, this is the spider in the web scenario. And the kinds of factors that the UK court will look at when it's deciding whether to grant an anti-suit injunction in this situation, one of the key factors will be how long is the foreign proceeding going to take? And is it intended to circumvent the UK result? If it would have that effect, and it's quick and fast, and it would get there before the UK, and it circumvents the UK, then it's really more about the mens rea of the person who is filing that foreign case and what they're intending to achieve with the foreign case that's most relevant. So the judge will look beyond what the parties have done on the papers and will look at the reasons why the parties have actually done it when deciding whether the anti-suit injunction is going to be relevant. Turning to a potentially sort of tangled situation for the future, as I'm sure everyone knows, the UPC agreement has now been approved by Germany. And this moves the UPC project significantly further forward and now makes it probably a practical reality for Europe. In the future, we could see situations where a UPC court would be asked to litigate an EP UK patent at the same time as litigating the unitary patent in one proceeding. And there would be a question about whether the UK court would anti-suit the litigation of an EP UK by the UPC court. I mean, I can see the advantages for a patentee. You get to litigate all of your rights in one court. It's one package. It's easy to manage, cheap or cheaper. And so you might want to do it. And I can see someone trying this at some point in the future. And this is going to be a question that we'll see an answer to, I think, going forward. And similarly, if the UK were to try the opposite, no, I think that would be a diplomatic scandal, potentially, to try to litigate a unitary patent in the UK court. But the same principles actually apply in analysing that, and whether the UPC court itself would then grant an anti-suit injunction to prevent the unitary patent from being litigated in some, particularly the UK court, which is the one that is, I think, most blameworthy when people are looking at why the UPC didn't move forward. So those are some of the issues that I think are on the horizon for us to look out for. For some reason, there we go. I would conclude with these points. We've seen anti-suit relief being granted in China, in Germany, these old civil law jurisdictions with, I think, sort of not so much tradition in anti-suit relief, and it's been rapidly developed as a remedy. To me, it seems that that sort of rapid development across the board more globally is going to continue. Looking at the UK in particular, we are going to see anti-suit injunctions used, I think, mainly because their framework, the jurisdictional framework for the UK is being set up so slowly, and it's taking a small eternity to get that up and running. Then we also see more courts worldwide being more ready to look at FRAND. And potentially one of the main ways to control that sort of duplicative behavior is going to be through anti-suit injunctions. My final point is that there is a chance, of course, that we would see some sort of international harmonization, maybe a further treaty from the Hague International sort of private law set of treaties is possible. The last situation that I saw there in my ABPI capacity did not suggest that IP was going to be included within its scope in a substantive manner, but that is the kind of effort that would clear up the anti-suit situation. Until we have that, I'm afraid anti-suits will probably be with us. And so that would be it from me. I'm going to try and figure out how I can stop sharing these slides.
Thank you very much, Harry, for the very deep presentation. So many content in such a short time. So thanks a lot for all your words. And so as time is advancing, so I now give the stage to Marcus Blasi, my dear partner. I think our presentation will be shorter, correct, Marcus? Because in Brazil, this is, until now, it's not an option. So, but I will let Marcus explain better now. Thank you, Ari.
Sure, João. Thank you very much. I will just share here my presentation, my brief one. Can you see it?
Yes,
okay.
Yes, it's very clear, Marcus.
Okay, thank you so much. First of all, thank you, João, for kindly introducing me at the beginning. As you said, I will be very, very fast and sharp in my presentation because I'm not properly a speaker here. I'm more there, I would say I'm a bridge between our speakers and the debates that will follow. So my idea here is to complete the mosaic and tell a little bit about how this phenomena, these anti-suit injunctions appear in the Brazilian or not appear in the Brazilian landscape. So, but I enjoyed the first time that I speak to thank again for Harris and for Ari for so magnificent presentations, very comprehensive, deep, and very clear, and also very, very sharp and straightforward. It's really, really nice to see how this matter is evolving, and it's really, really evolving. It's a changing scenario because we have a decision from July, just mentioned by Harris, and also the post-Brexit situation that changes considerably the situation in UK. So it's an ongoing matter that I try to bring to our reality here. So the first impression that you have about anti-suit injunctions, and I also thank Ari for this terminology, ACI and AACI. Otherwise, you're going to spell a lot of letters here, and also standardization patterns and SEPs and so on. This is very good and also sharpen the curiosity of the audience. So it's both utile and also very, very, very interesting for to sharpen the curiosity. So basically, in Brazil, in theory, anti-suit injunctions would be not acceptable, considering that here sovereignty of the Brazilian courts are the rule of law. So the federal constitution grants free access to domestic courts as a fundamental right. As a rule, Brazilian law does not recognize the international lease pendants and the doctrine of forum non-convenience that were developing in common law Of course, there are some exceptions due to international treaties or bilateral agreements. I would mention the Mercosul treaties in this sense that are enforced in Brazil, as well as some contractual dispositions. So as an exception. Therefore, when Brazilian courts are have concurrent jurisdiction of the dispute matter, for instance, in a case that the defendant is domiciled in Brazil, the obligation must be fulfilled in Brazil, or the suit is based on a fact or act practice in Brazil, the judgment that first becomes final on the under the Brazilian law is the only one enforceable. So as a rule, this is what happens in Brazil. Sorry, and as you know, Brazil is affiliated to the civil law tradition. So as Harris well told to us, for civil law judges, it's really hard to work with the idea of interfering with the jurisdiction of a foreign court as a rule, but it can be an exception in some cases. So just to mention a little bit the judicial landscape in this subject matter, and mention that, as Ari well said, it's not anti-suit injunctions is not something only for patent law and so on. If I studied well, it's applicable also to maritime and insurance contracts and other areas in the beginning. And there is a long tradition in common law countries. But here in Brazil, the Superior Court of Justice, that is the court in Brazil that adjudicate the application, the uniform application of the federal law, in an attempt to give some foreseeability for the Brazilian litigators. There was a dispute regarding the enforcement of an arbitration clause in a contract between Paramedics Eletromedicina and Brazilian distributor and GE Medical Systems Information, American company. And after Tecnimed filed the lawsuits both before the American and Brazilian courts to stay the arbitration proceedings, GMNS filed a counterclaim and obtained a decision issued by the American court, a ruling for the validity of the arbitration clause, and this is the important part, ordering Tecnimed to discontinue court proceedings in Brazil under a penalty of fine. Since Tecnimed did not comply with the letter, GMS pursued the enforcement of such judgment before the Brazilian courts, requesting the homologation, that's the procedure here in Brazil, of the judgment by the Superior Court of Justice, which was, of course, contested by Tecnimed. The court, despite recognizing the part of the foreign judgment that preserved the arbitration clause, the court found that the part granting the anti-suit injunction, ASI, violated the constitutional principle of access to justice, as well as the principles of international law regarding state sovereignty. So a typical civil law speech. This view was confirmed by another decision, a 2017 decision, in another contested homologation of foreign judgment. It's still there, and also there, CJ found that a foreign judgment cannot order a Brazilian judge or the parties to end a judicial proceeding pending before Brazilian courts. So it's a more restrictive understanding. However, there are some open issues that can raise the possibility of some changes in this first landscape. The parties may jointly request the termination or stay of an ongoing lawsuit. As Ari also mentioned, the anti-suit injunction, it's not directed to the judge itself. It's the foreign judge itself, but it's for the parties, directed to the parties. This was the case of one of this big, huge, and global dispute regarding SEPs involving TCT versus Ericsson that was already mentioned by Ari. And in this case, there was an ASI granted by the U.S. District Court of the Central District of California, Southern Division, ordering the parties to jointly request a stay of all claims anywhere in the world. From a practical perspective, the proceeding was stayed for during some time, and this is the notable part. The request came directly from a party and not from a foreign judgment. So the parties itself just asked for the stay, and so that's the reason that this procedure didn't was not submitted to the Superior Court of Justice for homologation. And there's another point that must be raised, that according to the Article 25 of the Brazilian Code of Civil Procedure, the Brazilian courts do not have jurisdiction to accept and rule disputes arising from a contract if the parties voluntarily selected a foreign venue to do so. This demonstrates a respect from the legislature to private autonomy. So it's another way to be far from Brazilian jurisdiction. In this scenario, it's really an open issue in Brazil. The consequences of an anti-suit or an anti-suit injunctions, it's not clear. And even regarding France, there is not a landmark case in Brazil that deals with the situation. So it's a road to be a path to be followed by the Brazilian petitioners. Of course, that looking at, as I said, the principles of sovereignty and free access to justice would be hard to have an anti-suit injunction enforced in Brazil. However, there is some situations regarding, as I said, voluntarily comply by the parties, and also in case of choose of jurisdiction that will let the parties follow the venue they prefer to litigate. Well, what can be projected for the future here? Brazil is in Latin America is a very promising market for 5G and also IoT devices. So, of course, these discussions will be in Brazil in some point in time. So that is very important for us. This panel is the practical confirmation of that there is an opportunity to discuss the matter and see how to make to build up a system that deals with this kind of situation. I guess we can project here that maybe we have floor for a paradigmatic shift in Brazil due to the relevance of these discussions. As Harris and also Ari told very well, some countries, some civil law countries reacted to the anti-suit injunctions, and we can mention the Munich and also the Paris decisions in this regard, but also China, for instance, and India, as mentioned in the very good and I strongly recommend article written by Harris about this subject matter. So as a conclusion, I would say here that as Ari well said, international harmonization here will be really desirable for providing clarity and enhancing the international patent systems, because ACI and AACI matters turn very clear to us how difficult it is to deal with this kind of situation. Thank you very much. And I as promised, I give the floor back to the debate that will follow. Thank you so much for your attention.
Thank you, Marcos. Thank you very much. So we have around 20 minutes left for the debate. So I strongly invite all the audience, if you have any questions, so if you prefer to use the chat, or even if you want to open the screen, and if you like to ask questions, please feel free and welcome to ask any questions to the speakers. And I know that Ari and Harris, they have themselves some questions to each other, very interesting and tricky ones. I'm not sure if we have time for all of them, but I would invite maybe Ari maybe to start, if you agree, Ari, to have maybe a question to Harris, and then Harris a question to Ari, and then the audience is invited also to ask any questions. Okay, so I don't know, Ari, if you agree, please. You are the first one to ask a question. Okay.
Yeah, sure, no problem. So I guess you know, and this is obviously to Haris, because this will be about Germany, but Germany is probably at the moment the most intensely sort of intense patent litigation jurisdiction in Europe. And so it's interesting to see that anti-suit injunctions are now the flavor of the day. What I was wondering about is that, do the courts in Germany distinguish between an act, sort of, you know, the harm that might be there because of a foreign anti-suit injunction that's in place, and a potential one that might come into place at some stage, and do they act preemptively?
Thank you very much for your question and the excellent presentation before, Ari. So as we also discussed in the presentation section, for German courts, the anti-suit injunction is a form of self-defense on the part of the patent owner under the German civil code. So under the German case law, the request for an anti-suit injunction that limits the exercise of patent rights might amount to a tortious interference with the proprietor's quasi-property right, as the courts say. And this means that courts can also grant relief at the interim stage, so before we have a request for an ACI. And we have seen that the Munich court doing that, issuing a preliminary injunction even at a point before the patent user had claimed any anti-suit injunction in another jurisdiction, but merely by threatening to initiate such proceedings, the court issued a preliminary order. Under German law, there must be the element of urgency for a court to issue a preliminary injunction. And when there are explicit threats that ACI proceedings will be filed, will be initiated shortly, German courts might respond with a preliminary injunction. And as you also mentioned in your case, where you had a timeline spanning hours, this can also be the case in Germany. You can have a German court responding to a request for an anti-suit injunction within hours, and this has happened in a case which is not publicly available, so I cannot say more. So we had an order being issued within hours. Now, I think it all goes down to the change of attitude among German judges. So we have seen, even in a public pronouncement, like in conferences, in European Commission workshops, we have seen German judges expressing quite open criticism of the concept of anti-suit injunction. So this is something that I think must be taken into account in general. Sure.
If I may take the liberty of a follow-up question. So, you know, in Germany, when you have a preliminary injunction, if you're a defendant, you can sometimes file a protective letter against that, which would then be read by the judges when they're looking at the request for a preliminary injunction. Could you file a protective letter against an anti-suit injunction saying that you wouldn't dream of applying for an anti-suit injunction in China, and you will never think about doing that, so you just file a lot of protective letters? Sounds a bit extreme to me.
Yes, to be honest, I cannot give you a straight answer to that. I'm not familiar with that, but I can say that preliminary injunctions in Germany are granted in very rare occasions. So to pass the bar of urgency is not that easy. So there must be a clear and imminent threat of an injunction in a foreign jurisdiction for a German court to do that.
Very good. Thank you very much for your answers and questions. So Haris, I think now it's your turn to have some touch some questions to Ari, and I read beforehand, and they are very challenging. So good luck.
Give it back.
I'm just since the UK left the EU, it has caused us a lot of concern. So maybe Ari can offer maybe some relief to these concerns and uncertainty. So my question relates to what extent the Huawei versus ZTE case law of the Court of Justice will apply in the UK now that it has left the EU. And I'm asking that because this framework has been incorporated basically in the case law of the UK courts, because we had cases going all the way up to the UK Supreme Court applying this framework, which also relates directly to the issue of the anti-suit injunction, because as we saw before, some courts in Germany view a request for an anti-suit injunction as an indication that the licensee is not willing. So the question is whether this framework stands now in the UK.
Well, that's it's going to be more challenging to keep my answer to less than half an hour than it is to necessarily answer the question. But that just demonstrates what a good question this is. I don't know. It's I can answer on many levels, but on one level, remembering that our firm represented Huawei in the Unwide Planet case, which is the one that you are referring to. So of course, I'm not speaking for Huawei here. These are just my private views on the situation. But Colin Burse and all of the judges above were very observant of the Huawei and ZTE decision from the ECJ. And of course, their decision was compliant with it. Does it do the UK decisions actually view that as the main framework for deciding FRAND? I'm not so sure, because on paper they do, but when you read between the lines, I think it's clearer that the UK is probably looking at at establishing the number in question. What happened at the end of the Huawei and Unwide Planet case was that the court gave an injunction which was conditional, so the Huawei was injuncted unless it concluded a FRAND license, and then the court said, well, here's one that I did earlier, so you can, if you do a FRAND, if you say yes to these terms, then that satisfies it and you are not injuncted. But unless you get a FRAND license, either on the terms that the court decided or Unwide Planet agrees to, then an injunction will bite. And if that's what it boils down to, then is the conduct of the parties, at some preliminary stage, maybe 2 years ago, is that relevant to that determination? I'm not sure that it goes to the number. It shouldn't really matter to the actual number itself when you're looking at the FRAND licensing terms and what the conduct of the parties was. And the unwilling licensee point, well, the UK background on that is slightly different, because I know what the ECJ said in Huawei and ZTE, because the view there is that you have to judge the willingness of both parties to actually enter into this contract, and that is one of the key factors that comes out of that case. But the concept of willing licensee and willing licensor is actually in English law, it's a damages issue. And there, what you're doing is you're estimating damages based on the hypothetical negotiation, and it's actually the quantification of damage where the willing licensor, willing licensee point comes in, not to whether somebody is in reality willing, because you have to, for the purposes of the hypothetical negotiation, you have to assume that the parties are willing. And so this determination about willing licensor, willing licensee did not fit well with the UK or English law framework on damages. It was very much like trying to squeeze a rectangular block through a round hole. That's how easy it was, I think, and so I'm quite proud of how well Colin Burse did when he eventually discussed it in his judgment. I think it was well treated. The other interesting thing about this is that whenever I ask a German lawyer, perhaps this is my opportunity, Harris, to ask you sort of a counter question. Whenever I ask a German lawyer, is competition law the only way that you can do FRAND, or could you also do it contractually? They would normally tell me that no, absolutely not. Antitrust is, or competition law is the only way forward. We've now seen that the US DOJ is deprecating the use of competition law antitrust in FRAND cases and SEP cases. And so I'm curious also to sort of see whether German courts might favor a different approach. The Dutch courts have their own approach, which is based on fairness and the negotiation during the litigation. And it is that there's even a slight difference between the way that the Dutch and the German courts do it. So I guess I'm sorry about the long answer, but I'm afraid sort of the conduct part of the Huawei and ZTE CJ analysis is very much like trying to push a square peg through a round hole in the UK case. They will do it, but it's not going to be pretty when it happens. I guess, my counter question then would be that, do you think the German courts will move away from this, or will they stick by this analysis?
Thank you very much for your answer. Just to clarify that I'm qualified in Greece, not in Germany, but I have been studying and working in Germany for several years now. German courts have for many years viewed the FRAND undertaking as a declaration and not a contract that you can enforce in court. And this has made a big difference on how cases are decided in Germany and in the UK or in the US, for instance. But I think the Huawei framework is not incompatible with a contract law approach. And we saw that, for instance, in Unwire Planet versus Huawei, where the UK courts applied actually both frameworks, both a contractual analysis and a competition analysis. So in my view, this is not it is not incompatible to apply a contract law remedy or a competition law remedy. What counts in the end is the essence, the conduct of the parties, whether you will assess this conduct under contract law and whether they have complied with their contractual obligations, or whether you will assess that under antitrust law. I think is the secondary element here. And the important is the willingness. And if the willingness is there, I think, or is not there, the courts will assess, and they have many ways to do that.
Thank you very much. I think we have time for a last question. I think Marcus would like to ask a last question to Ari. So Marcus, feel free.
Yes, just to close and thanking again for this very interesting questions and challenging, how João well said. Ari, just enjoying your participation, and also if Harris have also your view, please share with us regarding the patent litigation in Brazil. According to your experience, how are your feelings about the practice of patent law here in Brazil? If you can share with us your impressions, is very useful for us to improve and work on.
Yes, I'm happy to. From, I guess, obviously, I'm afraid you'll have to forgive me for this being an external view. So I know very little about IP litigation in Brazil, but the view that when I look at it in the context of multinational cases that we've handled, over the years, it's been clear that Brazil is the number one Latin American destination for IP litigation. The number of reasons. One is, I think, its popularity with plaintiffs because of the possibility of getting a preliminary injunction, and that is a big plus favoring the jurisdiction. Why it's picked by number of litigants. Together with that, of course, is the fact that it's a big market. Brazil is very large, and you know, if you've got the possibility of a preliminary injunction, and at the same time you've got a very large market which can be injuncted, then it's going to be attractive to plaintiffs, because the poor defendant, you know, who has my every sympathy, but the poor defendant is going to be injuncted from a very large market, and they are therefore going to be quite upset. This is going to put litigation pressure on people, and put it in a relatively fast time frame as well, which is a relevant part of it. Now, coupled with that is the fact that, you know, if you look at the number of participants on this call today, you know, we've got a very decent number of people. The profession in Brazil is large. And it's not like you're picking from 2 or 3 people who could potentially do a case, but there are actually quite a lot of people. And that's a testament to their high degree of professionalism that's evident in Brazil. And I hope I'm not being condescending when I say that. I don't mean to be. I certainly don't mean to be. But you know, the IP profession in Brazil is well advanced in its you know, its sort of level of education. It can handle all of the international level issues that arise. This is not the case when you look at some other jurisdictions. And so that's another, the sheer weight of the profession in Brazil is a big advantage, because that's going to come across really well to a client who's thinking about where should they litigate. Plus, of course, you know, the presence of Brazilian IP lawyers at various international conferences, which is another reason why clients notice Brazil as a jurisdiction. But I would say, you know, those are the factors that stand out to me, and so therefore I see, you know, when I look at litigation, say electronics litigation nowadays, the jurisdictions that tend to be most frequently involved, in addition to the obligatory Germany, you know, occasionally the UK is involved. Then you might see France. You would certainly see Brazil in a lot of cases, and you might see India, and you might see China. But Brazil, therefore, is in a relatively small club of competent jurisdictions that get frequently called upon.
Thank you for your very good answer, Ari. Thank you very much. I don't know, Haris, if you want to have any additional comments, Haris, on that.
Only 10 seconds, because Ari gave a very comprehensive response. I think that, Marcos, the answer, you gave it yourself during your presentation, where you said Brazil is a huge market for 5G, for instance. This makes it automatically a really good venue for litigation of other essential patents. And I think the view from Germany is that an increasing number of companies will litigate in Brazil in the years to come.
Yeah.
Thank you very, very much, Haris. Well, I guess we have run out of time, but if I could, João, just and on behalf of the ABPI organizing committee of this Congress, I'd like to thank a lot Haris and Ari for enlightening us with your knowledge and experience. So we are sure that the audience had the same impression that us regarding the quality and the going deep inside all the subject matter. So thank you very, very much. I wish you can go to Brazil and you can meet in person in a future Congress. And thank you very much again. And I just give back the word for Joan to close the event, and also to thank ABPI for providing us with the platform to discuss in a high level with all this fantastic participants. Thank you very much.
Thank you, Marcos, for your presentation, and Haris and Ari, thank you so much for your time and generosity, sharing your knowledge with us. So it was a great panel. Thank you so much. Thank you.